Dear students, viewers and the subscribers, welcome to the IAS Mentor. You are watching the series Indian Polity and we are in lecture number 87 in this particular series. As I already told, this series is going to be extremely useful to the students preparing for the UPSC examination and also for other competitive examination. The objective from the very first day is to provide a comprehensive idea on the subject Indian polity, and from the beginning we have come a long way. We have covered a number of important areas which includes the philosophical areas in the constitution like the fundamental rights, DPSP, preamble, and then we have covered the union executive, which is again a very important area. Then we have covered the legislature part. But you are yet to complete the legislature part. We are almost done with the union legislature. Now we have started what is called as a state legislature. In the previous class, I gave an introduction to the state legislature where we are trying to understand the constitution of state legislature, what constitutes the state legislature, how the legislative council can be created, abolished, how they are elected or they nominated. So all those basic information you will get it from the previous lecture. So now we'll move on from whatever we have seen in the last lecture, and in today's lecture let us try to understand the qualification and disqualification of the members of the state legislature. What are the qualifications one has to possess and what are the grounds on which they can be disqualified. If you have watched my lecture on the topic union legislature, we have already discussed the qualifications and disqualification of the members of the parliament. So here it is almost the same. The qualification and disqualification is almost same as that of the members of the parliament, but there are few differences. So let us try to understand as to what those differences. So let us proceed further. Let us try to understand as to what are the qualifications and disqualification when it comes to the members of the state legislature. So as it is given in the constitution, if you see the qualifications of members of the state legislature, first and foremost is somebody who wanted to get elected as a member of state legislature, be it to the legislative assembly or if a state is having a legislative council, be it to the legislative council also. The first and foremost qualification is that they should be a citizen of India. And if they are a citizen of India, then they should also possess the other qualifications. Unless and until they possess these qualifications, they cannot contest election. So this is the qualification to contest election in the first place. Citizen of India. And apart from that, they should take a oath or affirmation before an authorized authority. So who is this authorized authority? The authorized authority will be appointed by the Election Commission of India. So who is going to appoint the authorized authority? It is the Election Commission of India. The Election Commission of India will appoint this authorized authority. Usually the authorized authority is none other than the returning officer. You know that for every constituency, when the election happens, for every constituency there is a returning officer. He is called as returning officer because he is the one who has to certify the returning candidate. And who is a returned candidate? A returned candidate is someone who is declared to be the winner of the election from that particular constituency. So therefore, you'll have to clearly understand that there will be only one returned candidate, and that returned candidate has to be certified by the returning officer. So before contesting election, anyone has to take a oath in front of the returning officer. That's a mandatory qualifications under the constitution. And apart from the age requirement, so suppose if somebody wanted to contest election to the legislative assembly, they should not be less than 25 years of age. And suppose somebody wanted to contest election to the legislative council, they should not be less than 30 years of age in addition to these two qualifications. That is being a citizen of India and taking oath or affirmation in front of an authorized authority. So these qualifications are directly mentioned in the constitution. So this is very important. With regard to citizenship, with regard to the age requirement, and with regard to the oath that needs to be administered by the authorized authority, these qualifications are directly given in the Constitution of India. Apart from whatever is given in the Constitution, the Constitution also gives a power to the Parliament to make a law, and by that law also it can prescribe certain qualifications. So therefore, whoever wanted to contest election to the state legislature, they should possess all the qualifications, whatever is given in the Constitution and whatever may be prescribed by the law. But as students, what we have to take note of is that we'll have to be very clear as to what are the qualifications given in the constitution and what are the qualifications which are prescribed by way of a law that is made by the parliament. So accordingly, based on the power that is given to the parliament under the constitution, the parliament has enacted what is called as the Representation of People's Act. The Representation of People's Act 1951, and then it provides further qualifications. So what are the qualifications that is prescribed by the Representation of People Act? If you see the qualification prescribed by the Representation of People Act, it further says that somebody who wanted to contest election either to the Legislative Assembly or to the Legislative Council, whatever may be the case. In both the cases, they have to be registered elector from any of the constituency in that particular state. So here if you note a difference, they have to be registered elector from any constituency in that particular state. So what does it mean that they should be a registered elector from any constituency in that particular state? So for example, when we are discussing about the election to the parliament, that is to the Lok Sabha and Rajya Sabha, we have seen a similar qualification was there, but that qualification was he or she should be a registered elector from any constituency in India. There are 543 constituencies in India. Out of the 543 constituencies, they have to be registered voter from any of the constituencies. Whereas when it comes to the election to the state legislature, they should be a registered voter from any of the constituencies in that particular state. So for example, let us take the example of Uttar Pradesh. In Uttar Pradesh, there are 403 constituencies for the election to the Legislative Assembly. So therefore, a person who wanted to contest election either to the Legislative Assembly or to the Council, in addition to being a citizen of India, in addition to taking an oath or affirmation, in addition to fulfilling the age criteria, he or she should also be a registered voter from any of the 403 constituencies in that particular state. That means he should be eligible voter in any of the 403 constituencies. And apart from that, it is also very important, if you wanted to contest election from a reserved constituency, because we know that there are certain seats which are reserved for the scheduled caste and scheduled tribe when it comes to election to the Lok Sabha and also to the Legislative Assembly. So therefore, if a person wanted to contest election to any of the reserved constituency, not to the other constituencies, if they wanted to contest election from the reserved constituency, which is reserved either for the scheduled caste or the scheduled tribe, they should also be a person belonging to the reserved category from that particular state. So that is also very important. So when we summarize all these qualifications, what are the qualifications one has to possess in general, including both what is given in the constitution and by way of a law? First is one should be a citizen of India, then they should take a oath or affirmation in front of an authorized authority as appointed by the Election Commission of India. 3, they should fulfill the age criteria. 4, they should be a registered elector from any of the constituency in that particular state. 5, the next important thing is, suppose if they want to contest election from a reserved constituency, they should also be a member belonging to the reserved constituency in that particular state. So all these qualifications has to be fulfilled. Only when they fulfill all these qualifications, they will be eligible to contest the election in the first place. I hope this is clear to all of you. A similar qualification we have already seen in case of the members of the parliament. So now this is in case of the members of the state legislature. Now the next important thing is, the constitution not only prescribes the qualifications to contest election, the constitution also prescribes the disqualification from contesting the election. What are all the grounds on which one can be disqualified from contesting the election? And also, if somebody is already a member of state legislature, what are the grounds on which they can be disqualified? So the disqualification that we are going to discuss here, it will apply to both the categories of people, subject to some exceptions. So for example, anti-defection law is one of the grounds for disqualification of the members of parliament as well as the members of state legislature. But the anti-defection law does not apply to someone who wanted to contest election. Anti-defection law applies to someone only who is already a member of a legislature, either the parliament or the state legislature. But otherwise, most of the other disqualification that you are going to discuss today, it applies to someone who wanted to contest election to become a member of legislature, in this case the state legislature, or someone who is already a part of legislature, an MLA or an MP, they can also be disqualified. But however, here we are going to discuss only with regard to what is called as a member of state legislature. So what are the grounds on which someone can be disqualified? Someone is not a citizen of India or voluntarily gives up the citizenship. That means someone was a citizen at the time of contesting the election, but later, after getting elected to the legislature, he gives up the citizenship. Therefore, he can be disqualified to be a member of legislature, the member of state legislature, although he was elected as a member of state legislature. This is for someone who got elected. But someone who wanted to contest election, if he is not a citizen or if he has given up the citizenship, then also he is disqualified to contest the election. So, first and foremost is that on the grounds of giving up the citizenship or not being an Indian citizen. Second is someone who becomes an undischarged insolvent. So, what does it mean by an undischarged insolvent? An undischarged insolvent is someone, an individual who has taken a credit from a banking institution or for that matter any financial institution, and he has not repaid the debt. And because he has not repaid the debt, the financial institution from where he has taken the credit, they have taken some legal action. And the legal action is taken so that would enable the financial institutions to get back the credit. So, till the time the individual clears the debt in one way or the other, the financial institution can also come to a settlement, a reduced settlement. But till the time he is clearing those debts, he would be considered to be what is called as an undischarged insolvent. So, therefore, someone who is declared as an undischarged insolvent, and that person would not be eligible to contest election, and if he is already a member of state legislature and then he becomes an undischarged insolvent, then also he is liable to be disqualified. So, both the conditions or the undischarged insolvent will apply to both the cases. And then the third thing is someone holds an office of profit. Any member of state legislature after becoming a member of state legislature holds an office of profit, or someone before contesting the election holds an office of profit. In both the cases, they are liable to be disqualified. So, therefore, we will have to understand as to what exactly is this office of profit. The term office of profit is nowhere defined in the constitution. So, therefore, we will have to understand the term office of profit only based on what is called as the explanation or the interpretation which is given by the courts, especially the Supreme Court of India. So, what the Supreme Court of India has said with regard to what is an office of profit? The Supreme Court of India has already said an office of profit is any office either under the central government or under the state government or under the local authority. So, this is very important. It is an office either under the center or under the state or under any of the local authorities. It can be any type of office under any of these government by way of which the profit is receivable. So, the key word is profit is receivable. It is not necessary that the profit is received. Even if the profit is receivable, then also it can be considered to be what is called as an office of profit. Now, not necessarily an individual holds that office and he draws a salary, even if he is not drawing the salary. But if the office provides for the salary, but if this individual is not taking the salary, it does not matter. But if the office provides for the salary, if the office provides for any of the other benefits like free house, free car, free driver, whatever it is, any of the benefits is provided by that particular office, whether the individual exercises and enjoys that is not material, that is not to be taken into consideration. But what is to be taken into consideration is whether the office provides for a profit. If the office provides for the profit, then it would be automatically considered to be an office of profit. So, the key importance that you have to know is that any office either under the center, state or the local authorities, by a way of which if a profit is receivable, then that would be considered to be an office of profit. A person who is already elected as a member of state legislature should not hold on to any office of profit. If he hold on to any office of profit, then he is liable to be disqualified. A person who wanted to contest election should not hold any office of profit. If he is hold any office of profit, then he is liable to be disqualified. So, therefore, can a government servant contest the election? Yes, he can contest the election, but before contesting the election, he has to resign from the job and then he can contest the election. Otherwise, it would be considered to be an office of profit. And once they get elected to the members of the state legislature, then can they hold on to any of the office? No, then also they are liable to be disqualified. So, then you can ask me, if that is the case, how some of the MLAs are appointed as the ministers? How some of the MLCs are appointed as the ministers? As ministers, they draw some salary also. So, are they liable to be disqualified? they are not liable to be disqualified because there are certain exceptions to office of profit. It is not in all the cases if any legislator or an MLA or an MLC is occupying the office of profit, they are liable to be disqualified. Subject to certain exceptions, otherwise they are liable to be disqualified. So, but who can provide for this exception? So, if you read the constitution carefully, the constitution says, while holding an office of profit is a ground for disqualification, but does not happen in all the cases, there can be few exceptions. But who can provide for these exceptions? These exceptions can be provided by way of the law that is made by the state legislature. The state legislature can make a law, and by that law, the state legislature can prescribe the grounds on which or what are the office that shall be exempted from being an office of profit. Today, most of the state legislatures have made this law, and mostly they have exempted the ministers. So, any member of state legislature who is appointed as a minister, they are not liable to be disqualified under the office of profit because all these things are exempted under the law as passed by the various state legislatures. So, this is something that you will have to keep in your mind. So, what are the grounds on which they can be disqualified? Someone who is not a citizen or voluntarily gives up the citizenship, someone who becomes an undischarged insolvent, someone who occupies an office of profit, and then someone who becomes unsound mind. So, what does it mean by unsound mind? Unsound mind means people who are mentally not able or their functionality in terms of mental capability is not fully functional. So, in this particular case also they can be disqualified. So, someone who is of unsound mind can be disqualified from contesting election. Someone who had all the qualification, contested the election, become a member of state legislature, then later he becomes unsound mind, then also he can be disqualified. So, now remember all these grounds are directly mentioned in the constitution, and apart from that there is also one more ground which is also directly mentioned in the constitution is the anti-defection law. So, with regard to anti-defection law, I will just discuss about this anti-defection law very quickly, but one thing that you have to remember about the anti-defection law is, in case of an anti-defection law, try to understand the anti-defection law applies only to someone who is a member of the legislature. It does not apply to someone who wanted to contest the election, because anti-defection law applies to someone who is part of the legislature party. So, what does it mean by someone who is part of the legislature party? Someone is already elected and only for them it applies. But however, try to understand all these disqualification applies and it is mentioned in the constitution itself. So, what are the grounds on which the members can be disqualified? On the grounds of constitution: not a citizen of India, voluntarily gives up the citizenship, undischarged insolvent, holds office of profit, unsound mind, and anti-defection law. Well, the common thing is all these things are mentioned in the constitution, but the difference is anti-defection law applies only in case of the members of the state legislature, whereas the other four categories that you have seen here, it may apply to someone who wanted to contest election also, someone who was elected to the legislature also. And there is also one more difference that you have to understand between all these things. While the first four grounds, not a citizen of India, undischarged insolvent, holds an office of profit, or unsound mind, in all these cases a member of state legislature can be disqualified. But who is the disqualifying authority? The disqualifying authority is the governor of that particular state. It is the governor who is the disqualifying authority, and the governor acts on the advice of the council, acts on the advice of the Election Commission of India, or acts on the recommendation of the Election Commission of India. On the other hand, if you see the anti-defection law, in case of anti-defection law, who is the disqualifying authority? In case of anti-defection law, the disqualifying authority is a presiding officer of that particular house. If it is a member of legislative assembly, the speaker is a disqualifying authority. If someone is a member of a legislative council, the chairman is the disqualifying authority. So, this is basically what you will have to understand. But before I proceed the discussion, one thing other is important is the disqualification is not only given in the constitution. Apart from that, the constitution is also saying that there are also other grounds on which the members of the state legislature can be disqualified, but it is not directly mentioned in the constitution. But however, the constitution is giving this power to the parliament to make a law, and by that law they can be disqualified. So, you should be clear as someone who is preparing for the examination as to what are the disqualification given in the constitution directly. What are the disqualification based on the law made by the parliament? What are all the disqualification which applies to both members of the state legislature as well as who wanted to contest election to the state legislature? What are all the grounds on which the governor can disqualify? What are all the grounds on which the presiding officer can disqualify? So all those things I have discussed, except that what are all the grounds on which a member of state legislature can be disqualified based on the law made by the parliament. So now let us discuss as to what are all the grounds on which a member of state legislature can be disqualified based on the law made by the state legislature. So we'll try to understand that. So what are all the grounds on which they can be disqualified? One, if they are found guilty of any electoral offense or corrupt practice. See, the Representation of People Act is the law that is made by the Parliament which provides for further grounds for disqualification. So under the Representation of People Act, it also describes there are certain things which is considered to be a corrupt practice or an electoral offense. What is considered to be an electoral corrupt practice or an electoral offense? Somebody who is engages in booth capturing, somebody who is engaged in rigging of votes, somebody who is impersonating the voters, somebody who is using any undue influence. So these are all considered to be corrupt practices. And apart from that, anybody who is trying to polarize people on the grounds of religion, race, caste, sex, which would amount to violation of free and fair election. Now all these things are also considered to be electoral offences. So therefore somebody who is engaging in all these things, they are liable to be disqualified from contesting election as per the Representation of People Act. But this is not directly given in the Constitution. Somebody who is convicted of any criminal offense where the punishment is 2 years or more. So somebody is given punishment in a court of law for any criminal offense, but if the punishment is 2 years or more, then also they are liable to be disqualified. In fact, they are liable to be disqualified for another 6 years after completing their term of imprisonment, which is also given in the Representation of People Act. Somebody who failed to lodge the election expenses. As per the Representation of People Act, anybody who contests the election, they have to lodge election expenses within 1 month after the election result is announced. This is to see whether the election expenditure which is incurred by a candidate contesting the election is within the range or not. Because there is a range that is set in the law as to how much money they can spend. So officially this is the range. So therefore within the range they have to spend the money, and therefore they have to file the election expenses with the Election Commission of India. If they fail to do that, then that's also a ground for disqualification. And then the last thing is if they are convicted on certain offense. So this is very important. How it is different from this criteria, that is point number B and D. In point number B, if you see, if somebody is convicted of any criminal offense for 2 or more years, then only they are liable to be disqualified. But however, there is another provision within the Representation of People Act which says if somebody is convicted in a court of law, that itself is sufficient for them to be disqualified. The quantum of punishment is not important, but somebody, if they are convicted in a court of law, then that itself is sufficient enough to disqualify them. But however, in the category D that we are discussing right now, it is very important that they are convicted in certain type of offences, which is mentioned in the Representation of People Act itself. Say for example, some offences, criminal offences are specifically mentioned in the Representation of People Act, like someone who is convicted on hate speech, someone who is convicted under the Protection of Civil Rights Act, that is they engage in what is called as untouchability, somebody who is convicted under any of the terrorism related laws in our country, somebody who is convicted under the Prevention of Corruption Act. So somebody who is convicted under all these offences, they are liable to be disqualified irrespective of the quantum of punishment. So these disqualification may also apply to the members of the state legislature, but however these are not directly mentioned in the Constitution. But however, the first 4 categories along with the anti-defection law is directly mentioned in the Constitution. In case of anti-defection law, it is a presiding officer who is a disqualifying authority. In other cases, it is the governor who is a disqualifying authority on the recommendation of ECI, Election Commission of India. In certain cases, the Supreme Court of India said if they are convicted in a court of law, so therefore there is an automatic disqualification. Immediately they stand disqualified. So these are all the different ways by which a member of state legislature can be disqualified from contesting election. So someone can be disqualified from contesting election to the state legislature, or a member of state legislature can also be disqualified. Okay, subject to the exceptions that you have discussed. So with that, we come to the last part of our discussion is what is called as the anti-defection law. Now, first and foremost, you'll have to understand, I have already discussed about the anti-defection law. So already have elaborately discussed in the legislature part, that is in the union legislature part, when I am discussing about the parliament chapter. But again, I am discussing it only for the benefit of the students who may not have watched that particular video. So someone who is watching this particular video directly, if the student have already watched that particular area, you can skip this also, because I am going to repeat the same thing, because the Constitution of India provides the same grounds for disqualification for the members of the parliament as well as the members of the state legislature when it comes to anti-defection law. So it is the same information. The only difference is the disqualifying authority for the members of the parliament is the presiding officer of the respective houses in the parliament. That is the Speaker Lok Sabha and the Chairman Rajya Sabha. Whereas in case of the state legislature, the disqualifying authority is the presiding officer in case of the legislative assembly and the presiding officer in case of legislative council. Apart from that, each and every single provision that you have already discussed is the same. So when this anti-defection law was brought in the first time, it was by the 52nd Constitutional Amendment Act in 1985. So before that, there was no provision for anti-defection law in our constitution. It was majorly to prevent the ayaram gayaram politics. So what does it mean by ayaram gayaram politics? Is someone, a person who got elected from a particular party ticket, after getting elected from a particular party ticket, he joins another party, and from that party he joins another party, and then he comes back to the original party. This is basically what is called as ayaram gayaram politics, or basically it is what is called as political defection. That a person who gets elected from a particular party, he defects to another party. Now, what is the problem with this political defection? The problem with this political defection is it brings a lot of instability to the government. To prevent this, the 52nd Constitutional Amendment Act was made in 1985 under the leadership of Prime Minister Rajiv Gandhi, and they brought in this anti-defection law in order to prevent what is called as political defection. So the idea is, this 52nd Constitutional Amendment Act also inserted a new schedule that is the 10th schedule in the Constitution that elaborately discussed, or it elaborately provides the ground as to what can be seen as political defection, and it also talks about what can be the punishment in case of political defection. So majorly the anti-defection law was brought in to act as a deterrent for political defection. So today, what is the punishment for political defection? The punishment that can be given for political defection is disqualification. That any member of parliament or a member of state legislature engages in political defection, they can be disqualified to be a member of parliament or a state legislature. But for which it has to be proved through an inquiry which will be done by the presiding officer of that respective house, that first the defection has happened. So this is basically, you will have to understand with regard to the anti-defection law. So to basically put in what is anti-defection law, so anti-defection law means it is trying to prevent political defection. Political defection means a person who got elected from a particular party ticket, who after getting elected from that particular party ticket, he joins another party. So therefore he engages in what is called as defection. And for the defection, his act of defection, he is liable to be disqualified. And who is authority to disqualify him? The presiding officer of that particular house is liable to disqualify him. But however, under the anti-defection law, the presiding officer cannot take any suo motu action. When I say the presiding officer cannot take any suo motu action, the presiding officer cannot take any action on his own. So that is what he'll have to understand. He can take action only on a petition that is filed by others who is affected because of this political defection. So this is basically what you'll have to understand with regard to the anti-defection law. So I think it is quite clear till the point whatever you have discussed. Now, what are all the grounds that is given and the 10th schedule which can be seen as what is defection? There are 4 grounds which is given in the 10th schedule of the Constitution which can be seen as what is called as defection. First thing is, if any member of state legislature voluntarily gives up the party membership, which basically means that a person got elected from one party, he joins another party, then it is assumed that he is voluntarily given up the party membership. But the Supreme Court of India has said it is not necessarily whenever they join other party, it can be seen as voluntarily giving up the party membership. It may also be because of the reason that he may continue to be in that particular party, but he engages in what is called as anti-party activities. that while someone being a member of a particular party, but he continues to do things that would affect the party interest, that can also be seen as voluntarily giving up party membership. So therefore, they are liable to be disqualified. Second thing is, if any member of state legislature abstains from voting or vote contrary to the party direction. So normally how things happens in the state legislature, or for that matter in the parliament, whenever any bill is introduced, any motion is introduced, the party will give directions to all the MLAs of that particular party or the members of legislative council of that particular party as to how they have to vote when that proposal is brought in or when this bill is brought in. So normally the members should vote as per the directions of the party. If they vote contrary to the directions of the party, or if even abstain from voting, abstain means they don't vote either in favor or against. In both the cases, they are liable to be disqualified unless and until they have taken prior permission to act contrary. So this is what is the next category. If any independent member joins any political party, then also he is liable to be disqualified. So what does it mean by independent member joins any political party? An independent member means someone who has not contested election from any party. He is an independent candidate. He is not belonging to any political party. So an independent candidate, once he elected as an independent candidate, he should not take the representation of any party, or in other words, he should not join any political party. If he joins any political party or take the membership of any political party, then also he is liable to be disqualified. A nominated member joining any political party after the expiry of 6 months. Who is a nominated member? Today, the nomination or the nominated member is possible only in the Rajya Sabha. There is no nominations in Lok Sabha. So if any person nominated to the Rajya Sabha, at the time of nomination, he does not belong to any political party. And then subsequently, if you want to join any political party, he can join. But how much time does he have, or he or she has to join a political party? He or she has 6 months to join a political party. If they join 6 months, it's okay. But if they join after 6 months, then they are liable to be disqualified. All right. So this is what you'll have to basically understand with regard to defection. So all these things, I think that it is quite clear to all of you. Okay, now under all these grounds, who is liable to be disqualified? Any member of state legislature. But who is authority to disqualify them? The speaker is authority to disqualify them in case of legislative assembly. The chairman is authority to disqualify them in case of the legislative council. So all these things has to be quite clear in your mind. But is there any time limit within which the presiding officer has to disqualify them? The constitution does not provide for any time limit within which they have to be disqualified. But however, there are certain exceptions in the constitution. What are those exceptions? The exceptions was brought in by the 91st Constitutional Amendment Act subsequently. But the 52nd Constitutional Amendment Act, when the anti-defection law was brought in, they themselves have provided for some exceptions. What is the exception that is there? If there is a 1/3 split, then there is an exception. So what is this 1/3 split means? Suppose let us assume a party is there and this party has 60 MLAs in a particular state legislative assembly. Out of the 60, if 1 or 2 persons join another party, they are liable to be disqualified. But if minimum 20 MLAs split from the party, then they are not liable to be disqualified because there is an exception of what is called as 1/3 split. So minimum 1/3 means the 20 members minimum, if they split, the 20 members are not liable to be disqualified because it is seen as a faction. It is seen as an ideological difference. So what happened over a period of time, that instead of retail defection, wholesale defection started happening. That means a person thought, instead of I alone going away, if I alone join another party, I will be disqualified. So therefore, I will take other members also with me, and hence therefore it will amount to what is called as 1/3 split. So then it was creating a lot of problems again. So then the parliament realizes, so therefore they made an amendment to the anti-defection law by way of the 91st Constitutional Amendment Act in 2003. Now the word 1/3 split was replaced with what is called as 2/3 merger. So therefore now the 1/3 split does not exist. What is the exception that is given in the constitution is only what is called as 2/3 merger. So what is this 2/3 merger? Again, if you say party X has 60 MLAs, out of the 60 MLAs, 20 MLAs split. Sorry, instead of 20 MLAs, it should be 2/3. So there shall be 40 MLAs. 40 MLAs who shall split will not only split, but they'll have to merge with another party. Say, example, party B. They go and merge with party B. So this is basically what is called as merger. So when this both the conditions satisfy, then they are not liable to be disqualified. But however, the biggest problem with the anti-defection law is what is the term merger is nowhere defined in the constitution. So therefore, different cases, different interpretations has been given by the courts. So that problem still persists as to what is the exact definition of merger. But for the purpose of examination, if they give what is the exception under the anti-defection law, you can always remember it is 2/3 merger. Now, when the anti-defection law was brought in, the anti-defection law was challenged in the Supreme Court of India because the anti-defection law was brought in by the 52nd Constitutional Amendment Act in 1985. When this anti-defection law was brought in, a case was filed in the Supreme Court, and that case came to be what is called as a Quixote-Holloan case. Very interesting case. It challenged the constitutional validity of anti-defection law. Now, why they challenge the constitutional validity of anti-defection law? The major reason as to why they challenge the validity of the anti-defection law, constitutional validity, is on the ground that it is taking away the privileges of the members of the parliament. I have already discussed as to what are the privileges of members of parliament when I discuss the union legislature. Again, I will discuss it, but not elaborately in this class, but the basic idea I will try to give it. So if you look into the constitution gives certain privileges to the MPs and MLAs, which includes the right to freedom of speech and vote in the parliament or in the state legislature, for which they are not liable to any proceedings in a court of law. So on the one hand, this privilege is given, but on the other hand, it is saying that if the MPs or MLAs vote contrary, they are liable to be disqualified. So therefore, the case that was brought to the notice of the Supreme Court argued in this case, or in front of the judges, the matter was put in such a way that the parliamentary privileges are taken away by what is called as this anti-defection law. So therefore, it violates the parliamentary privileges, and hence anti-defection law is unconstitutional. But the Supreme Court said, we do understand the members of the parliament are having privileges, but those privileges cannot be exercised in such a way that would bring instability to the government. So therefore, in the interest of the stability of the government, we uphold and we validate this anti-defection law, and hence the anti-defection law would continue to be valid. The second thing that was also challenged in this particular case, if you look into the original provision of the anti-defection law by the 52nd Constitutional Amendment Act, I said who is the disqualifying authority under the anti-defection law? It is the presiding officers who are the disqualifying authority. The original version of the act, that is the 52nd Constitutional Amendment Act 1985, said that once a decision is taken by the presiding officer with regard to the disqualifications of the MLAs in the state legislature and MPs in case of the parliament, that decision shall be final and binding. It cannot be questioned in a court of law. So therefore, this provision was also challenged. So first is they challenge the constitutional validity of the entire anti-defection law. Second, they also challenge the power that is given to the presiding officer to disqualify them and making that decision of the presiding officer final and binding. So the court said while the presiding officer can have the power to disqualify the members of the parliament or the state legislature, but the decision will not be final and binding. If the decision is final and binding, you are taking away the power of judicial review of the courts. So therefore, we will not allow you to take away the powers of the judicial review of the courts, because the judicial review is part of the basic structure, and hence the decision of the presiding officer is subject to judicial review. The presiding officer here acts as a tribunal, nothing more than that. And any decision of a tribunal is subject to judicial review in the higher courts. So therefore, the decision of the presiding officer can also be challenged in the High Court, and then subsequently an appeal can be made in the Supreme Court of India. So therefore, to that extent, it has been modified by the Supreme Court of India. So today, try to remember with regard to anti-defection law, the anti-defection law is very much valid, but however, the decision of the presiding officer is not final and binding. It is subject to be challenged in the High Court, and subsequently further appeal can also be made to the Supreme Court of India. Or in other words, the decision of the presiding officer is subject to what is called as judicial review of the higher courts. So this is what basically you have to understand. So I am quite sure that you are very clear about the concepts that you have discussed as to what are the qualifications, disqualifications of the members of the state legislature, including the anti-defection law. So now we are coming to almost the end of the discussion for this particular lecture. So I want to just put you across this particular question. So try to solve this question. Statement 1, consider the following statement. Statement 1, if a member of a state legislature holds an office of profit, he or she is liable to be disqualified. If a member of parliament or a state legislature occupies an office of profit, is he or she liable to be disqualified? Statement 2. Only the presiding officers of the state legislature has the power to disqualify the members of the state legislature. It is not specifically talking about anti-defection law. It is in general talking about the disqualification. So whether the statement is right or wrong, which of the statements given above are correct? So try to put your answers in the comment box. Do participate in these questions. It is very, very important for you to ultimately to be able to solve the questions. That is the ultimate end, and therefore you can also clear the examination. So one thing I repeatedly say to the students, what helped me in clearing the examination is my repeated practice. So do not take it for granted that once you have read that you will be able to solve it, because while solving it we may make lot of mistakes. It is better to make mistakes during practice rather than making mistakes in the examination. Alright, so with that I'll wind up this particular session. If you like my lecture, please share it with your friends and whomever you know who is preparing for this examination. And I'm sure this series is extremely going to be useful to the students preparing for various competitive examination. And if you have any queries, please do not hesitate to reach out to me. You can think me as your friend, guide, mentor, but please do reach out to me in case of any queries. Thank you very much. All the very best.